Increasingly, I think we need to consider whether the rules of procedure for court proceedings are a barrier to access for justice. Some provinces and the federal court have launched extensive, far-reaching reviews of their rules of civil procedure. Ontario announced such a review in late January of 2024. While the review is expected to take 2 years, there are going to be ongoing changes that will be made throughout that period. And similarly, in early April of 2024, the federal court announced the creation of a special subcommittee to conduct a global review of the federal court rules. Early signs from both of these reviews point to a comprehensive rethink of rules of procedure. Ontario's civil review of the rules will be guided by several principles, including an attempt to try and triangulate the values of accuracy, time, and cost, because delays and runaway costs are the most pressing threats to proportional justice. But also it will consider consideration of the contribution that each existing rule makes to the truth-seeking and procedural fairness, and that must be balanced against any inefficiencies associated with that rule, including any potential for its abuse. Some of the things on the table include the potential for a broader role for streamlined applications, or even a single simplified form of pleading to start a case. There will be easier ways to serve parties, establishing firm, enforceable timetables at the outset of a proceeding, maybe even increasing the threshold of what counts as a relevant document that must be produced in litigation. One option being considered is the potential elimination of oral discovery in certain kinds of cases, and eliminating refusals from answering questions on discovery, except where privilege is implicated. There'll be more active case conferences and potentially even a cap on the number of motions. All of these kinds of reforms, which will be considered over the coming years, will prioritize substance over process and will, in my view, have the real potential to meaningfully increase the pace at which civil justice is administered.